Actually, the principal of Vivekananda Law College. Welcome you, ma'am. I would also like to welcome all the teaching and non-teaching staff and also all students of Vivekananda Law College. So today's guest lecture, it is a continuation of previous workshop where Sir has done with Historical School of Jurisprudence. So today Sir will be continuing with Sociological School. So without any hindrance, let us start with session. Over to you, Sir.
Okay, am I audible? Are you hearing me?
Yes, sir.
Then good morning everybody, I will start. Did you have joined?
Yes, sir.
Okay, good morning once again. In this previous class I have discussed about the historical students. And I have told you that each school emphasizes one or the other, not all, the aspects of the concept of law. Because the concept of law consists of several elements, several phenomena. That is why it is not a single phenomenon. So that is why that so the many theories of law emerge, many schools of law emerge. Each school emphasizing, sometimes overemphasizing one or the other aspects, leaving out the other aspects of law. So I had told you that so the positivist jurisprudence or analytical school of jurisprudence emphasizes on human law, how the law is being laid down by human beings for the guidance of themselves. Whereas I had told you natural law argues that in every society there are objective moral principles based on what is good and what is bad. So whereby on the basis of this, so the society derives so many moral standards, and natural law argues that human law should conform to these moral standards. And historical school, I have told you, argues that the law emerges in the history, it evolves, so it develops by virtue of social interaction. At different point of time, at different places, we have different laws because these people have different history, different culture. But at the same time, so these three theories have their own weaknesses. I have told you, and therefore you know that after all, law is one aspect of several norms or rules governing human conduct in a society. So all these three theories never emphasized on the importance of law for the society. So it is in fact several people claim that law is not the only end in itself. It has to serve some social purposes. And so there are two basic types of sociological jurisprudence, schools of law. One emphasizing law and its role in the society. That is called sociological jurisprudence. And there is another which tries to argue that law evolves in the society. So they try to argue, develop what is called as social basis of law. So in fact, law is required for certain purposes only. So it is one instrument by virtue of which we try to resolve conflict between individuals. So then another, they try to argue that every law evolves in the society. So that is why we find different laws. For example, that so that in some societies, so that they have one law, Islamic law, another society, Hindu law. At one point of time in the European society, natural law was focusing. Second impact, that natural law has become religious law, canon law. So then, of course, after Renaissance, that we rejected all this natural law, canon law, because then we try to emphasize on rational law made by rational human beings, that is positive law. So whereby we try to, of course, overemphasizes the what is called as the role of human beings and authority in law. That is how Austin developed the law as its command of the sovereign. So then, why this command is not followed? So the IPC enacts to the one should not commit murder or one should not commit theft. But in the newspaper here, day in and day out, many deviate behavior, many murders, but according to our Parliament Committee report, that India has the very least conviction rate. So then, in fact, one police officer was telling, in India, if you have a political connection, that means if you are connected to a very powerful politician, you can commit any number of murders and get away with it. So in India, in Mandya, CCD, so in Mandya, there is a proverb. So the person having 2 acres of land, so they can lead a very moderate good life. So if a person has got 2 to 5 acres of land, so he can, in fact, lavishly spend and lead a luxurious life. So if he has 5 acres to 10 acres of land, so he can visit 1 week Bangalore, another week Mysore, and like that. So he can, in fact, that so the contest elections and become a leader. If he has more than that, he can commit any number of murders and get away. So this is how, in fact, that so the people and society. For example, that one reason why in India, so we have, in fact, a very low level of commitment to law is a mindset of people that is being occasionally articulated. So the one, of course, a very high status, highly educated educationist. So while making a speech, he argues that so the IPC never asks you to not to commit murder, not to commit theft. It only says if you commit murder and caught, you will be imposed with a particular punishment. If you commit theft, you will have this punishment, provided it is proved. So if you have the ability to escape from the punishment, you can do any number of murders, any number of theft, robbery. So this, in fact, that this attitude of people in the society is articulated and it expresses in several ways. That is why that so the a law-abiding person should be respected, but in India society glorifies the law violators, lawbreakers. So that to understand these things, that so that we have to analyze or understand the social purpose of law. So that is why, in fact, that these are all the certain conclusions we have drawn on the basis of the study of society. So that, in fact, that so that it is Auguste Comte, a mathematician, who introduced the study of society from scientific perspective. So we can, in fact, observe the society. We can formulate certain conclusions, develop certain theories. So that the scientific study of society was introduced by Auguste Comte, the father of modern sociology, and he introduced for the first time the idea that the law is an aspect of society. So that is why that in one society, for example, that so that in early society there were corporal punishments. Even now you find in 27 BDs. So that is how, in fact, that corporeal punishment was there. Even now it is there in certain Arab countries for as a punishment for certain. But slowly, of course, that corporeal punishment was replaced by imprisonment. Of course, here also it could be in every society imprisonment as a punishment was recognized. But in India, of course, in certain backward societies, this punishment sometimes the criminologists or criminal lawyers argue that may not be that effective. That is why this corporeal punishment, even the death sentence should be made part of legal system. There are, of course, who argue that so the death sentence, capital punishment is against what is called as human rights. So these types of conclusions emerge out of the study of law from a sociological perspective. So that, in fact, at one point of time, of course, that so the lawyers, judges, they were not so much concerned about social study of society from the point law from the point of view of society. It is in fact, that criminologists and sociologists, they started studying law. Of course, some early sociologists were actually natural scientists. See, Auguste Comte was a mathematician, and Roscoe Pound, the founder of modern sociological jurisprudence, was a natural science person. So in that way, so the study of society by the lawyers, jurists, in fact introduced this school, the sociological school of law. It has two branches. One is sociological jurisprudence. The other one is sociology of law. Sociology of law is concerned with study of evolution of law in the society, the development of law in the society, and they try to emphasize the role of law also. So that now coming to the sociological jurisprudence. In fact, it was Ehrlich, von Ehrlich, a Danish jurist, introduced the idea of the function of law, and the law exists in a society to perform certain functions. The primary function of law in the society according to Irving to resolve conflict between individuals and the society. So it was Irving who introduced the idea that law in a society exists for the purpose of resolving disputes because human beings live in a society. So wherein in fact that because of the egoistic nature of human, there is there will always be scope for one or the other there will be fight. And that is why that some biologists argue, philosophers also argue that man is a combative animal. He is always fighting with another. It may not be always be physical fighting. So that for his survival, so that avarice, greed, all these things will impact that human beings to generate conflict in the society. So that is why here we introduced the idea. For example, that so now everyone wants to become rich. So then that so the best way to become rich is to become a dacoit or a public servant in a country like where of course India is not the only country. So wherein in fact that several people, individuals, particularly of course university law college students. So when I joined KarnatakaUniversity and I became a London. So while visiting, that all these students, they don't have any law books in their hostel, in their room. So their fundamental aim is to become sub-instructor and get money. Because, they can collect money, bribe, and crores of which. In fact, that several students who are caught recently, of course, were university law college students who have become DYSPs and others. So a lawbreaker, so this particular instinct in human generates a conflict between that individual and the society. Society wants individuals to earn money by lawful means, not by corruption. So that is why every crime results in a conflict between the individual and the society. Similarly, that some students, particularly law students are in India or in Bijapur. So to become a sub-instructor, one must have degree. So to pass BA degree, they must copy at least English because English is an alien language, and there are majority who admit English ಮಾತ್ರ ಕಾಪಿ ಹೊರದೆ ಪಾಸ್ ಮಾಡಿದ್ದು ನಾವು. ಆಮೇಲೆ ನಾವು ಕೋರ್ಟ್ ಸಬ್-ಇನ್ಸ್ಪೆಕ್ಟರ್ ಪೋಸ್ಟ್ ತಗೋತೀವಿ, ಆಮೇಲೆ ಜನರಲ್ಲಿ ಸೇರ್ತೀವಿ. That is why that Indian public servants, some of them, there may be exceptions, they are worse than Ghazani Muhammad's soldiers who looted India. What is the difference between Ghazani Muhammad's soldiers and the Indian public servants? As from class 4 to majority of them. They are worse than Ghazani Muhammad's soldiers because Ghazani Muhammad ordered looting of enemies, whereas these people loot their own land. So then why? How to impact the law? The purpose of law is to resolve conflict between these individuals who want to become rich overnight by corruption or by crime or by robbery, of course, and the society. That is why that Bentham analyzes the impact of crime on the society. So that is why a criminal must be punished. So the crime results from conflict between individuals, of course, to become rich. So that everyone wants to become rich, but the society wants the individuals to earn money and become rich. So then, of course, some business people, if you go and ask, ಮೋಸ ಮಾಡದೆ ದುಡ್ಡು ಮಾಡೋಕ್ಕಾಗುದಿಲ್ಲ ಬೆಂಗಳೂರಿನಲ್ಲಿ, ಬೆಂಗಳೂರಿನಲ್ಲಿ ಮೋಸ ಮಾಡಲೇಬೇಕು. So these types of mindsets sometimes, make this law ineffective. And then in fact, that's our mindset. So the law will never say that you should not commit murder. If you are caught, this is the punishment. So if you acquire the ability, that is why that everyone wants to become minister. There is one book, of course, Arun Shauri, Parliamentary System of Government. So why people want to become politicians? He discusses in one chapter. To escape from the clutches of law. That is why I have to know that conviction is. So our Mazudi police wala example I had given. So the police, in the previous class I must have said that the Mazudi police wala. So that he takes 50 rupees and leaves the people instead of prosecuting and punishing him. So this is this lowest level category of public servant PC. So if you go to the higher level, so that is why that. So the people have a conception. So in politics, money is that. Business, so hakodu rakiyamsu. Duddu hakodu dudtini. So one corporator himself was staggering, of course. If one becomes, of course, it is somewhere in 90s. If one fellow becomes mayor for 1 year, so he need not earn anything. He can make a lot of money. That is enough for him and another 2 generations. So that is why, in fact, that why this is happening in India, it is because the law is increasingly becoming effective. So that people are not, of course, that giving too much importance to law. In fact, that why law is required in the society. In fact, that early society, the law in its present form was not there. But still, crime was increased. So many criminals used to be punished. Whereas now it is not possible. Because the people try to, in fact, respect money, power, they were worship. So of course, it is one reason is according to natural lawyers. So it is the inability of the individuals and the society to appreciate the law-abiding nature. So according to one study conducted by Prof.K.R.Aithal, there is one book, Crisis in the Indian Legal System. So it is in fact, that why in India the law-abiding ethics is deteriorating is because of the inability of the government to punish the lawbreakers and the inability, of course, the sort of aversion towards enforcement of law in the society by the members of. So there are many people, in fact, that they are weary of giving complaints when somebody commits crime. I should bother. That civic sense is deteriorating. Anyhow, so according to Eric, who introduced the idea, notion that the law has a specific social purpose, and that purpose is resolving conflict between individual interests and the interests of the society. So, in case of conflict between individuals and the society, we had argued that individual interest must prevail over the interests of the society. So the individual interest, that means in the interest of our people to earn money, should be in accordance with society. That is why you know that. So that shopkeeper is telling, see, in the morning till in the evening, by sitting in the shop, I could not earn 25 rupees, but 15 minutes, 15 minutes you have earned 150. 200 rupees, out of which, of course, 50 rupees to bus police part. So then, in fact, you know that law should punish the pickpocket. So then, of course, our Basu, instead of punishing, you know, that he tried to promote the interests of the culprit, criminal. Thereby, you know, he tried to make his money. He wants to become rich. That is why, you know, the many in this society so want government job. So anyhow, so the law should punish. Of course, you know that why this anti-corruption act is ineffective. So even in fact there are oppositions. When the move to establish Lokayukta was started in India, Lokpal. Of course, at state level it was done. So in 1962, on the basis of the recommendations of one Santanam committee, so we must have an institution similar to Swedish ombudsman. But even now it has not been properly established. State level, of course, some states. So these institutions fail to carry out the purposes of that particular law, that is, minimizing or eradicating corruption in public life. So the law is ineffective, and it is the contribution of sociological jurisprudence in emphasizing the study of law. That is why you know that socio-legal studies have become prominent in the modern jurisprudence. In fact, you know that even in modern sociology. So in fact, these types of studies will in fact introduce how the law should be enacted. So when it will be effective. So all these conclusions we draw from what is called as socio-legal studies. So it was introduced by, in fact, you know that very, and that, of course, you know that most prominent among sociological theories was Roscoe Baum, the Roscoe Baum, who elaborated the study of law in a society. Then the question is that Hearing has not, in fact, you know, that elaborated how to resolve conflict between individuals and the society. So every law is directed towards, every rules of law are concerned with resolving one or the other type of conflict. So then the question, of course, Hearing stopped at this stage where he argued that In case of conflict between individual interests and the societal interest, social interest must prevail over individual interest. So the social interest, for example, by punishing pickpocket, we are upholding the social interest as against this individual pickpocket's interest to earn money. So in that way, in fact, sociological jurisprudence try to argue that according to a rate, social interest is superior to interest. But it is not as simple as I had told you that in case of a pickpocket, of course, you know that the punishing a pickpocket upholds the interest of the society because society wants an individual to earn by lawful means. So this pickpocket, in fact, you know that not earning lawfully. But then, of course, you know that so that it is not always possible to argue that social interest alone must prevail over individual. In certain cases, the individual's interest also must be upheld even against the society. So that is why, for example, you know that a person should not be arbitrarily detained. So your habeas corpus, you must have heard of a person detained can go to the High Court and get a writ of habeas corpus for his release. So wherein in fact you know that policeman might have arrested this fellow, he must be lawfully arrested. Of course, even in that case, this individual may be the beneficiary, but ultimately the social interest prevails. In the sense that in this society, no one should be arbitrarily detained. So anyhow, but in this case, of course, you know that it appears that through the law and try to protect individual interests. So that is why, in fact, you know that Roscoe forms this theory. I am going to discuss only three aspects. First, in his book on philosophy of law, so the Roscoe analyzes the concept of social purpose of law. So wherein in fact you know that this theory, in fact according to Roscoe, every legal rule has an end in itself. So it exists for the purpose of serving a particular purpose. The society picks up and fixes a particular purpose for law. So that purpose is resolving conflict in the society with least friction and waste. This he calls the concept of social integrity. So whereby you know that so the primary purpose of law is social engineering, that is to resolve conflict peacefully. So that is how in fact you know that so that every law, courts, everything, in fact you know that the entire justice department, courts are established for the purpose of resolving conflict between different interests. So that according to Roscoe, how every law, for example, you know that we take the example of the Hindu law of marriage. So you know that according to Hindu, classical Hindu law, marriage binds husband and wife for 7 incarnations. Hindu law, primary principle is that. So the marriage binds the woman and the man for 7 generations, 7 words. That it is of course a blind, some believe it blind, we don't know whether it is rational or whatever. So that is one impact of this is that no divorce. So that society marked and impact, that so the violence of men against women increases. Domestic violence lately. So the earlier law would not resolve this conflict, or for example, that the Hindu law for the first time in 1955 and the Hindu Marriage Act introduces certain grounds of marriage. So this purpose of this law is to resolve conflict within the family, husband and wife, with least friction and risk. So that when there is in fact no provision for divorce, in fact that so that if the harassment of one increases, there will be suicide or murder because no divorce. So that is why that so that the crime increases. This law, in fact, instead of resolving conflict with least friction and risk, it generates conflict. That is why that. So on the certain grounds, the divorce should be permitted. But at the same time, that so that it cannot be permitted always. So then, of course, that so these people, they MC peace in the society. So that they can easily get divorce and go ahead. Of course, now. So that is increasing. Anyhow, so this divorce law. So the general interest of the society has to be taken into consideration. So there must be provision for upbringing the offspring. Who should look after the children born out of particular marriage and instead? So the husband and wife gets divorced, but some provision the law has to make because that only human beings have a long gestation period, even biologically. For example, that this birds. So they look after their offspring only for 1 or 2 months until they learn how to fly. Thereafter, that so this mother will not be people. So within 1 or 2 months, so the child will become self-reliant. Whereas human beings, 18 years, so they have to be brought up. Then, of course, they have to be educated. So many problems are there. That is why how to fix it. So this relationship should be strong and should last for long. That is why that. So once it was thought that, so there should not be any divorce. But now, of course, when marriage becomes unpalatable, so that in fact, that living together leads to misery of both the parties. So then let them separate and be happy. So that is why that so that we have to resolve conflict with least friction and waste. So we introduced certain grounds for that. Not all. Because that so that the wife cannot ask divorce on the ground that husband has failed to provide him with that latest so the smartphone of 1 lakh rupees. So you must have that in newspapers, several these commit suicide and so the quarrel and other things happens now because of so the smartphones. Earlier, at one point of time, of course, one wife was murmuring. There was professor in the law department of a reputed university. And she murmurs because that her husband is not, my husband is not good because he is not taking me to the FGR films every weekend. This cannot be a ground for divorce. That is why the law should balance. So the resolve of this conflict is friction. So then how do we have to recognize interest? That is why second aspect of the last compounds jurisprudence. This theory of interest. So what is an interest? So interest generally represents wants, desires, and expectations of individuals which press for legal recognition and protection. So they are called individual interests. So every society should recognize certain individual wants, desires, and expectations to be met in the society, and the law should protect. That is why the primary purpose of criminal law is to protect the individuals, in fact, so the physical integrity, bodily integrity. So no one should not commit assault, crime. So everyone's interest in his person should be against the onslaught of others. That is why that our law, criminal law, should try to protect individual interests against others. So the criminal offences against persons, so offences against property. So these are all they should try to protect the interests, ಹಿತಾಸಕ್ತಿಗಳು ಕಾಪಾಡಲಿಕ್ಕಾಗಿ ಇರಬೇಕಾಗ್ತದೆ. Otherwise, that if there is no law pertaining to theft or robbery exists. So anybody can rob. So there will not be any security to your person or property. So that is why. So the certain individual interests. So these interests, so the how to classify interests into three categories. So individual interests, then public interest, and then social interest, of course. So the individual interest, social interest, and then public interest in catalogs. So there are, of course, 66 individual interests. So some, so the 80 and 97 are so the social interest, some 60 public interests. So his 3 volumes of Jurisprudence. So when he elaborately discusses, he discusses, of course, that all the aspects of jurisprudence. So it is available in KarnatakaUniversity. All the 3 volumes. So where in fact that so the first class of interest are individual, Vyaktikana interest. So that the law must protect certain individual interests. So it is to protect his interest in his person, the law against his body. So it tried to balance, in fact, social interests with that of individual interests. So at the same time, the society has to punish. For example, if A attempts to commit murder of B, so that B should be punished. It is the society wants to protect the interest of all of its members. That is why an individual cannot commit murder, etc. So this law tries to resolve conflict, but at the same time, that so all sorts of killings cannot be protected by law, because that at a certain time that is why the law against homicide. Homicide means killing a human being by another human. So there are, of course, four classes of homicide. If you read in fact Kenny's outlines of criminal law or Smith and Hogan's book on criminal law, that I am referring to these books and other things you wrote down. The students who are interested to study more, so will be guided. So I am, of course, referring to certain books and other things. So at least that those students can easily go through if they are interested. Read. Anyhow, so the Maharashtra Board classifies interests into three categories: individual interests, social interests, and also public interest. So individual interest means certain individual desires, wants, expectations that should be protected and secured through legal rules. So the social interest means, in fact, the society wants to protect certain interests. So desires, wants, expectations of the society. For example, that. So the law punishing is that. So the upholds society's interest in this, namely that the society wants individuals to earn lawfully, while if the individuals fails to protect the societal interest, so the law can punish them. And of course, public interest means an interest of the political organization in the society. So that is why we have certain laws. For example, that law relating to sedition. So often, in fact, that this law comes in conflict with the individual liberty of free speech, and in day in and day out, in fact, some cases, newspaper report emerges. So then, public interest try to uphold the expectations of the political institution, the government. So that is why we have certain laws like laws against the crime against the organized government, sedition, overthrow of government by force, treason. So these are all the laws try to uphold what is called as public interest. So that is how we try to know that. So then the third aspect of Rashtra's theory of is that how to resolve. Because that courts are concerned with, legislatures are also concerned with resolving conflict with the least friction and risk. So how we can resolve? We require certain standards that Rashtra formed. So when the individual interest should prevail over the societal interests or vice versa. So that is why in the large majority of the judicial decisions, so what is involved is the application of law to uphold whether individual interest or social interest. So in fact, for example, that you take the example of what is that? The recent, in fact, the cases concerning what is that? Nagar Parishad case, where in fact that one old man was imprisoned and what is that? The conflict between Naxalites and the government. This represents the conflict between individual interest and the public interest. See, when individual interest lies in fact, the protection of individuals, freedom of speech and expression. So the individuals, in fact, the propagation of ideas. And then, in fact, in the name of course, that propagating ideas, they cannot preach violence, cannot glorify crime. Of course, sometimes, that these people used to argue that crime is to be met with crime. Injustice must be met with injustice. So the terror must be met with terror. So in fact, of course, these ideas have also a role to play in society. That is why, in fact, that the courts, while dealing with the cases of tradition, then of course sedition, they have to balance the interests of individuals and the interests of the organized government. If the law tries to protect, in fact, that in the name of public interest, if it protects the interest of some individual, for example, that so the one law was passed, 39th Amendment to the Indian Constitution, which was subsequently abandoned to protect the interest of individual. Indira is India, India is India. So that is why whoever makes derogatory remarks on what is called the scurrilous publication can be punished with 6 years imprisonment. That is what scurrilous publications act was passed. Does this law really promotes the interests of the government? India? No, it tries to protect the interests of India. That is why the court has to balance. So that is why in many cases, in fact, that so the cases of tradition, sedition, so the courts have to balance the individual interest versus interests of the government or society. But at the same time, that individuals cannot be allowed to speak nonsense. So then, in fact, the persons making seditious speeches should be punished. For example, that if a Naxalite leader in a secret meeting, so that he gives sermons or orders to the armed Naxalites to the effect that you go and kill A, B, C, D. They are the enemies of the working class. They are, of course, that. So that some politicians, in such cases, the law should punish the person committing seditious speech. So that is why. So that in this case, the law tried to resolve by employing one standard, namely that the individuals will not harm others without justification. So in a civilized society, it is possible to presume that no one commits intentional aggression against others. So that is how we know that. So that he announces 5 jural postulates. So these 5 jural postulates, first one is that In a civilized society, we may be able to achieve that the individuals, members of the society, refrain from committing intentional harm. So if they commit, they should be punished. So the entire criminal law is based on this general postulate or an assumption. So it is only an assumption which cannot be verified because you know that society occasionally, sometimes frequently, people committing intentional acts. But by and large, we may be able to achieve. So that is why whoever makes intentional aggression, the law must punish. So secondly, in fact, you know that so the second jural postulate is based on the idea that no one intentionally cause loss to other party by dealing with others in the society. In a civilized society, it is possible to achieve that the people making certain promises, they keep promises, they won't cause loss. So the entire contract law is based on this dual postulate. That is why you know that in contract law we have several principles. And thirdly, in fact, you know that third dual postulate is that so if in a society, so we cannot live without committing some harm sometimes. That is why they drive. So maybe negligently or because of users, other users of the road may not be able to avoid certain accidents. Or for example, you know that so that industries, so they impact industrial accidents. So in such cases, for example, if individuals harm or cause loss to others or injury to others in certain ways, they should make good the loss caused to them. This is the basis of law of tort. So it tries to resolve conflict that arises in this way in the society. And then in fact, the fourth general postulate is that so in certain circumstances, individuals if they cause harm by virtue of their act, they must be able to compensate so that your pension could have strict life, etc. So that is how, in fact, he identifies that in a society there are certain standards evolved over a period of time, with the help of which we try to resolve. So at one point of time, at one age, so it is individual should interest should be. So he catalogs so many interests, like that as freedom of speech, physical integrity, etc. So these interests the law has to protect. So then in fact in case of conflict, that by applying these standards, so no intentional aggression. So these are certain jural postulates with the help of which we try to resolve conflict between different individuals and the society, individuals and the state, public interest. So these are all the fact, that the purpose of law is to resolve conflict with least friction and waste. So he applies the analogy of engineering. So that the basic purpose according to Rashtrapat is to resolve conflict with the least friction and waste. First is in fact that is the first purpose of law, and this can be done through the theory of interest by classifying these interests. And then of course the conflict between interests cannot be resolved unless we have certain standards. these standards he calls jural postulates. They are all, of course, certain standards which exist in human society. That means, that. So only intentional killing we punish seriously, while other forms of killing we will not take it seriously. So that is why that in criminal law the homicide is classified into four categories. One, that is justified homicide. The law allows individual to commit homicide when a soldier killing the soldier of an enemy soldier during combat is justified in killing. So there are, of course, second category, so under certain circumstances. So if it is not possible to avoid killing, so it becomes excusable. For example, a public servant. So during holy war kills, immediately afterwards there will be one magisterial inquiry into the holy war. Why? To ascertain whether that is justified or not. So the third category, of course, that. So where in certain cases, that killing cannot be avoided or it happens. Not because of your intending to kill it, but because of the turn of certain events. Accidental death. That is why that. So the murder also has been classified into two categories: culpable homicide and murder. So intentional killing, murder, is more serious. So where in fact death penalty, etc. So that is why that these are all these four are due to what is called as the resolving conflict in interests with least friction and waste. So that is how, of course, then this theory has got one important limitation as to this jural postulates. For example, the first postulate I had told you that in a society we may be able to assume that no individual commits intentional aggression against others. Is it possible to assume this in a terrorist society or Taliban society? In a civilized society, he qualifies. Or, for example, that so this jural postulates can be legitimately employed to resolve a conflict in an industrialized society where conflict arises on account of interests. Whereas in fact, that less democratic, less civilized society, the conflict emerges not because of conflict of interests, but because of values, ideas. So the communal rights. So that even America is not free from these types of conflicts, black lives matters. So these types of conflicts, that for example, terrorist killing and innocent people. There is no conflict of interest in these cases, in fact, that is why. So the Escobar's theory can be applied to study the rule of law in highly industrialized Western American society or European society, where people are not bothered about religion, caste, creed. So that is why in a backward society like economy, of course, yeah. So in certain respects it is morally backward. So the caste conflicts, so riots, they do not occur on account of conflict of interests, but they occur. That is on account of values. That is why you know that Rama Janmabhoomi conflict or desecration of Ambedkar statue conflicts. These are all special types. That is why you know that they cannot be so easily resolved. These people you know that we cannot perceive that they won't intentionally harm. So anyhow, so with this in fact you know that sociological school of which try to emphasize on social role. Of course, I am unable to in fact you know that more involve sociality of life. So it's not possible for me. So anyhow, I get only two earrings and Roscoe Pope's theory. So with this, I think it is sufficient. Let me conclude by thanking you all for again giving a patient hearing. And if you have any question, doubt with reference to these two theories, sociological jurisprudence of hearing and Roscoe. So you can come up with your questions. I will try to answer that. Thank you. Thank you.
Thank you, sir. And now I request the participants, if there is any question, you can ask. You can put it into the chat box.
Chat box. Is there any questions?
No, sir.
No. Huh? Okay, then let me.
No, sir.
Okay, okay.
Yes. Uh, I guess we can step into the last session. A vote of thanks.
Okay.
Yes, it's my privilege to render vote of thanks on behalf of this esteemed institution. So, so I would like to sincerely thank our today's speaker, Professor K.R.Aithal, sir, for the wonderful session. Thank you very much, sir. And I would like to extend my heartfelt thanks to all the governing council members and Director of Legal Studies, that is Dr. B.K. Ravindra sir. And also I would like to thank Mrs. Akshata A.P. Principal, Vivekananda Law College, and all the teaching and non-teaching staffs of Vivekananda Law College. Thank you one and all. And also I would like to thank all the students for participating in the session. Thank you one and all.